Hey guys, Kristen Marks here, founder of My Pink Lawyer. Women lawyers committed to saving your loved ones time, money, government interference, and family disputes with practical and effective family succession planning. So today I'm going to answer the question for you, what makes a will legal in the state of Florida? Florida residents must meet the following requirements in executing a will in order for it to be legal in Florida. Number one, it must be in writing, either handwritten or typed. No oral wills are valid. For example, telling your child who you want to give your assets to without writing it down. That's not legal. Number two, the will must be signed by the person making the will at the end of the document, or in the event the person is unable to sign the will, they can direct that his or her name be signed at the end by another person in their presence. And number three, the person signing the will must do so in the presence of two other signing witnesses who must also sign in the person's presence and in the presence of each other. In other words, everyone needs to be signing in the same room, one right after the other. Contrary to popular belief, a will does not need to be notarized in order to be valid in Florida. However, if the will is also notarized at the same time as its execution, it is considered self-proving and is easier to admit to probate after the person's death. Florida does not recognize what is known as holographic wills. These are handwritten or typed wills that are not witnessed. An example of a holographic will would be if you sat down and wrote out a letter to your family about your wishes regarding your assets after you die. That is not a valid will for Florida residents. Although Florida generally recognizes out-of-state wills, Florida courts do not recognize holographic wills, even if they are recognized by the state in which they were executed. Although do-it-yourself wills are becoming increasingly popular, there are many possible missteps that can be made in the proper execution of a Florida will that can inadvertently render the will null and void. In our office, we follow a strict protocol with the execution of our clients' wills to guarantee that all execution requirements are met. In over 2 decades, none of our wills have ever been thrown out by a court for improper execution. To learn more about the legal requirements for a Florida will, download our free book at pinklawyerbook.com. Also, be sure to subscribe to this video channel to be notified of future postings. Bye!